stage here, but I have denied the motion to dismiss, and so therefore do I understand that the petitioner is asking to proceed today on the petition to nullify lien?
That's correct, Your Honor, yes.
Okay. And is the respondent prepared on this matter also?
Yes, Your Honor.
Okay. And so I recognize we're falling a little bit behind on time. I'm also sensitive to you may need a break. Would you like a 10-minute break before we turn to this next part here? Mr. Beckett?
No, we're okay. We can proceed.
Okay.
We can proceed, Your Honor.
Okay. And with that, I'm good to proceed also. So we are now moving to the petitioner's petition to nullify lien. I'm going to have you pause only so that I can get the pertinent filings in front of me for this matter. All right. And with that, you know my practice, counsel. I do give the entity with the burden the ability to start and finish the arguments. I do want to hear from both sides here. But with that, Mr. McDonald, at this point now you will start things off, and when you're ready, you may proceed.
Thank you, Your Honor. And being cognizant of the time, I will streamline as much as I can. So, Your Honor, this is a summary proceeding under the statute pertaining to whether or not a document recorded against real property, in this case a notice of interest or NOI, is a wrongful lien such that it should be removed from the property. We're not asking the court to evaluate any other part of the petition except for that issue. Your Honor, the arguments that we've presented in our briefs, we believe pretty much stand on their own, but there's essentially three fundamental issues that render the notice of interest a wrongful lien. First of all, it's based on a document, a contract, an attempted contract that was never signed by either party, but more particularly by the party to be charged, which would be the petitioners. For statute of frauds purposes, that's pretty key. The document also violates the statute of frauds because it's not signed. That's the second point. And then the third is that the underlying transaction was actually never fully formed due to no meeting of the minds as to the purchase price, the scope of work and improvements, and even the parties. The purported lessee identified in the lease agreement was Skull Valley Medical Clinic, LLC, which is, as far we presented evidence to the effect that that entity does not exist. It doesn't exist under the laws of the state of Utah, and we couldn't find it in any other jurisdiction either, and I don't think that's in dispute. But what is in dispute is who the parties are. If the parties do not have a common understanding as to who is involved, I'm not talking abstracts. I mean, obviously we know that the Native American, the Skull Valley Band tribe is involved. But we do, when we sign a contract and when we are assigning rights and so on, we do kind of have to get down to brass tacks. And in here, the brass tacks was an LLC that doesn't exist. So the main points are that I want to touch on are that the petitioners at all material times own the subject property. It's an IRDA, 624 West, 3700 North. My client was contacted by a real estate agent pertaining to the property. That turned into protracted discussions about this company, Warrior Spirit. That's my understanding is a DBA of the respondent LLCs. They wanted to lease the IRDA property. They also wanted to purchase the property, so there were discussions going back and forth on both of those. The parties met at a title company in January of last year to sign the deal, or not to sign the deal, but sign the lease. It was going to be a lease option. There was a dollar amount that was given. But the lessee is listed in that document as Skull Valley Medical Clinic, LLC. We presented evidence to this court that entity doesn't exist, so no valid contract can exist between petitioners and a non-existent entity. It therefore stands to reason that a notice of interest cannot stand where its underlying interest is invalid. There's various statements in the document that I think have some bearing. I mean, paragraph 3. In paragraph 3, there's a waiver of due diligence on the tenant's part. I think both parties were trying to negotiate quickly and in good faith because they. Actually, I take that back. My client was operating in good faith because she really did want to lease this property. But in order to lease property, and you have to comply with the statute of frauds, and she wanted to refinance the property. She had to refinance the property because she had a loan on it that was and is still ongoing and is very onerous. But in order to do that, she had to have a lease that she could show the bank. And so that's why they got together to sign this this lease option. Now, along with it, there was a separate document that is not the lease option, but it's a notice of interest that the parties said, well, yeah, you can go ahead and put that on you can record that in the county records so that you have a placekeeper, so that you do have an enforceable interest. But, Your Honor, by way of proffer, my client contemplated that notice of interest being signed alongside the lease, the option agreement. But at the closing, they didn't sign it. They took it and they said, we'll look at this and sign it and get it back to you later today. And that never happened. To this date, that lease has never been signed by either party. So subsequent to that is when we ended up with, there were further extensive discussions and negotiations about improvements to the property and about changing the purchase price of the property, which we would submit reflects a lack of a meeting of the minds. If the parties haven't signed an agreement and if they're still negotiating months after they had a sit down over the lease, and they never reached a consensus as to the purchase price and as to the overall improvements to be made and so on, then there was no meeting of the minds. Your Honor, we cited a bunch of text messages. I think I'm going to skip over those. Those are a matter of record, but I think they do reflect a lack of a meeting of the minds between the parties. I'll just stand on that in the interest of brevity. So to come down to the key points of law, there was no contract because there was no meeting of the minds as to the purchase price, the scope of the work to be included, the closing date, the parties, in that case the party tenant was a non-existent entity. Also, the closing deadline has lapsed. It was, I believe, August 15th, sometime thereabout last year. So it can't be enforced right now, even if there was some sort of way to get around the lack of a signature. Which brings me to my next point. There's no compliance with the statute of frauds. The notice of interest is expressly predicated on a written lease option. It says, quote, buyer hereby claims an interest in the following described property by reason of an unrecorded option agreement dated January 8th, 2021. So, but that document was never signed. And if it's not signed, it doesn't comport with the statute of frauds. The option agreement is not enforceable because it is not signed by Holly Jones, and she's the party to be charged. We would also make an issue. We would also make an argument pertaining to standing because the notice of interest was signed by Skull Valley Health Clinic, but the option agreement lists Skull Valley Medical Clinic LLC as buyer. So respondent LLCs are technically not even a party to the contract that they purport to rely on when they say, hey, we have a notice of interest. Well, not according to the document that you didn't sign. So I think that's a pretty substantial defect in there. The lease option is unsigned per Utah Code 25-5-1. It's unenforceable because it purports to create an interest in real property, because it has to be in writing and it has to be signed by the party to be charged. And Utah 25-5-3 states that a lease shall be void unless in writing and signed. So with that basis of facts, we turn to the wrongful lien statute 38-9-102 subpart 12, which defines wrongful liens. It's not if it's not expressly authorized by this chapter, then it's a wrongful lien. That one doesn't apply. The next part is that it's a wrongful lien if it's not authorized or contained in an order. Well, there's no order here. It's not a wrongful lien if it's signed or authorized pursuant to a document signed by the owner of the real property. That, Your Honor, we would submit is the one that applies here negatively, because in order for them to, in order for the notice of interest to be valid, it had to have been signed, authorized pursuant to a document signed by the owner, and they don't have that. It's on its very terms. It references the option agreement. The option. It says the notice of interest is based on this option agreement. That option agreement was never signed by the petitioners. So 38-9-203 creates a civil remedy, which I don't think we'll get into because that's the scope. But if we fast forward to 38-9-205, we have to look at the procedural requirements for relief under that statute. Subpart 1, you have to file a petition in the county. Petitioners have done that. Subpart 2, we have to state with specificity a claim that the lien is wrongful. We would submit that we have done that. Subpart 3, it has to be supported by sworn affidavit. The petition is supported. It's a verified petition. Subpart 4 says that the hearing may only determine whether a document is a wrongful lien and may not determine any other party or legal rights of the parties or restrict or other legal remedies of any party. So I guess I don't need to delve into that because that deals with the jurisdictional issue that the court has just been addressing. Subpart 5 says that if the court determines that the lien is wrongful, it shall issue an order declaring the wrongful lien void ab initio, releasing the property from the lien and awarding costs and reasonable attorney's fees to the petitioner. And then subpart, the rest of them I think are not quite there. So, Your Honor, under 38-9-205, that statute says, quote, if following a hearing the court determines that the recorded document is a wrongful lien, actually, I'm sorry, I'm repeating myself. So we're asking that the court declare the notice of interest wrongful and void ab initio. We're asking the court enter an order declaring the lien released and of no force or effect. And we'd also ask that the court include a provision in the order prohibiting respondents or their agents from reporting any further documents against the subject property without first seeking and obtaining leave of court from this court. The statute doesn't really speak to that point, but I think the circumstances here are such that it really is required. My client is genuinely concerned that the respondents or someone working with them, if this court were to release the notice of interest, the respondents would just turn around and record another document, and then we'd deal with another transfer to federal court, another 4-month delay, and so on and so on. Meanwhile, she's paying a substantial amount of points on a very onerous loan that she needs to get refinanced, and she can't get it refinanced until the notice of interest is released. So that's the crux of our position.
Thank you. That's fine.
Thank you.
All right. Yeah. All right. I heard from Mr. McDonald. Mr. Beckett, when you're ready.
Thank you, Your Honor. It's kind of hard to see where my client can pay $225,000 with a check that is signed on the back of it that references the IRTA property that we're talking about, gives it to Holly Jones, and she deposits it into her bank. Her agent gives her a document that's called a notice of interest, has her sign it. It references Skull Valley Healthcare, LLC. And then after Holly Jones deposits that money into her bank account and that document is filed, and oh, by the way, the property's not even ready to be delivered to my clients yet because there's still somebody who lives in it. And there's this ongoing discussion about, hey, we said that we'd buy the property for, $420,000, and then, or $430,000, and then you'll do $75,000 worth of work on it to improve it, to make it so that we can take it. But we have to wait till the people leave, and then you're going to do the work because you say you can do it, and we'll give you the money that you're going to use in order to improve your property. For them to come back and say it was wrongful, that a notice of interest was recorded against the property. That doesn't quite strike a chord, and principles of equity would suggest that the notice of interest was not wrongful, given that it was filed, it was created by petitioner's agents. It was given to my client to sign at a location that was directed by the petitioners, that a cashier's check changed hands that went to the petitioners. She cashed it, and then she directed her agents to file it. I mean, that doesn't sound like that was some sort of wrongful action to color a title of the property where the Skull Valley Healthcare didn't have an interest. They had a $225,000 interest. Now, what is that $225,000 interest to? Just because petitioner misdrafted the contract, and there was a lot of problems with that contract that was just given to them the morning of, and everything had been a verbal communication back and forth, and the $225,000 was to secure the modifications and amendment and changes to the property. The expectation was that this property would be sold to my clients and that they had to front the money so it could be changed and modified. All of these things then say there's really just a question here on whether or not there's a contract. Now, statute of frauds, that is legitimate. But doesn't the check with a signature on the back that acknowledges that this relates to a specific property, doesn't that show that there's actually a contract? And the reason for the statute of frauds, going all the way back into law school, was because we want to make sure that people can't just make up stuff, right? We want to make sure when there's an interest in land and property that somebody just can't walk in and say, yeah, he told me last night at the bar that I could have his house. There's something more here, and that's $225,000 that changed hands. And there's work that was done. And the text messages showed that there was work that was done. And the text message showed that there was work that was done unsatisfactorily. And there's questions about how that roof was put on and how the property was amended and changed and modified. And there's questions about what the value is now, amended down from the 517. Now, that doesn't mean that they didn't have a meeting of minds on the value. The value is 517, and that 517 includes $75,000 worth of repairs and changes and modifications that was fronted by my client with a $225,000 check. This isn't a wrongful lien. It just boils down to that. There's an interest in this property. And if there's needs to be a suit for specific performance, and there needs to be a suit for specific performance. There's procedural hurdles that needs to happen in this case before we get to this point, and whether or not my client can file a counterclaim or not, because if we walk into this court filing a counterclaim, we have to make sure that this court acknowledges that we have jurisdiction here. And if we file a counterclaim, then we say, you absolutely have jurisdiction. And the court's already answered that question today. So, if this court strips off that notice of interest, Ms. Jones can run down and sell that property tomorrow. And my clients are not protected in their money, nor are they protected in the investment, nor are they protected in the improvements to that property that were done with their money. They negotiated for a property. They deserve the benefit of the bargain. Now, just because there was a problem with getting that written down and agreed on January the 8th, well, again, the property wasn't even ready to be transferred on that day. There's people living in it. We haven't gone through the discovery process yet to figure out when did Holly Jones get access to that property, how did she get access to that property, what did she do after that point, what did she do with the money that my client gave her in order to improve the property. We know that there were some cameras that were installed in the place by my clients. That's material improvements. Do they not have an interest in that? Of course they do. And if this court takes the argument that says, hey, whoa, we need to strip that off, what happens? Holly Jones gets $225,000 just for the benefit of it? And even if she's to say, well, I'll just give the money back, that ignores the fact that this was a negotiated contract back in January 2021 with the intention that it would transfer, that after the improvements were made, that it would transfer, that everybody would come in under good faith and do it. I'll tell you what's good faith, is giving a $225,000 check without having a contract in hand that guarantees it.
Let me ask you to comment on this. What was argued to me by Mr. McDonald is that the pertinent document is not signed by Ms. Jones, and also the respondent LLCs are not a party to any of the pertinent writings or contract. Can you respond to that, please?
Yeah, one is a red herring. So the contract, the option contract, which was never going to be signed in the first place because it was absolutely onerous, and it included a acceleration clause that they would forego $225,000 if they didn't meet certain character or qualifications or circumstances or otherwise, and that was a document that was created by Holly Jones herself, and just because she misput the name up at the top, well, that's not a party in interest here. Now, the reference under the notice of interest specifically says we were referencing back to an option agreement. But again, that was a document that was created by her own agents at the title company, right? And they were, and my clients were directed to sign it in order to get the $225,000 check, with the promise that, hey, we're not going to deposit this check until we have a deal, right? And then the notice of interest will be filed. And if you look at the terms of the contract even say that she wouldn't even deposit it until 3 days after the contract was signed. So why would she go out and deposit a $225,000 check when she doesn't even have a signed contract? Well, that's because they actually do have an agreement, Your Honor. They have an agreement for 517. That's why she deposited the money. The option agreement wasn't for my client. It was for some other entity that doesn't exist, or maybe it was a Scribner's error. Who knows? But the fact is that there isn't a signed contract. Okay? And because there's not a signed contract, accepting the fact that there is a signed check, and that signature on the back of the check is as good as a contract, says that there's an interest in that property. Holly Jones acknowledged the fact that there was a contract when she deposited the money, when she signed the check, and she directed her agents to file the notice of interest. That wasn't filed by my client. It was filed by her agent. That's what the facts will show.
That's helpful. Thank you.
So, any questions, Your Honor?
No questions at this time. Thank you.
Thank you.
All right, Mr. McDonald, as I mentioned before, you'll have the last word. Let me start you with this. I know that what you've initially emphasized, that there's just a lack of contract here, and therefore there's a violation of this statute of frauds here, and that court should then determine that the notice of interest is a wrongful lien. What's been argued in response is that there is a contract because there's a signed check with your client having signed that, and that is sufficient for the notice of interest, and that it's not just the signed check at issue. There's other things been argued here. There's text messages and all the things that have been fleshed out here so far in terms of other considerations the court should look at to indicate that there is a sufficient notice of interest. Could you start with, why is the signed check not sufficient for the notice of interest and for this court to decide that that would not constitute a wrongful lien because of the signed check?
Well, Your Honor, in order for a contract to be a contract, it has to include some basic elements. It has to have the parties. It has to describe the material terms, and it also